now in session. Please stand, or please be seated.
Good afternoon, everyone. Introductions?
Good afternoon, and thank you. Christian Singwald of White & Williams on behalf of the appellees. I have with me today my co-counsel, Kim Coker and Thomas Goutman, both of Shook, Hardy & Bacon in Philadelphia, and both have been admitted pro hoc vice.
Welcome.
May it please the court, good afternoon. Ralph Durstein on behalf of the state of Delaware through Attorney General Kathleen Jennings. And with me at council table is Christian Wright, Allison Gaffney, and Kyle Mueller. All the last two admitted pro hoc for the purposes of today.
Welcome. And you may proceed.
Thank you. May it please the court. Today, as we stand here, Delaware's fish, wildlife, lands, wetlands, and waters are contaminated with toxic PCBs that interfere with the right of the public to use, enjoy, catch, and consume these vital resources. And that is a direct result of the conduct of the defendant in this case, Monsanto. Monsanto is a company that produced nearly all the PCBs ever sold in the United States over a period of some 4 decades. It aggressively marketed and promoted these chemicals to its customers, despite knowing that PCBs were toxic to humans and wildlife, and that the ordinary use and disposal of PCBs and the products containing them would inevitably end up in the environment. Now, Monsanto seeks in this court, as in the lower court, to distance itself from the environmental damage it has caused to public lands and waters in Delaware. And the argument is they distributed PCBs through other manufacturers, which is true. But that does not confer immunity on Monsanto for their conduct, where their conduct in producing all the PCBs was both foreseeable and the proximate cause of the harm sustained by Delaware lands and waters. The state's claims in this case are not novel. An action by the English Crown to address polluted waterways was a classic example of a public nuisance and a trespass action at English common law as much as 1,000 years ago. This is not a case about sales of a defective product to consumers. It's not a product's liability case. It's about affirmatively misrepresenting and promoting a raw material for use in products where Monsanto knew, as we allege in the complaint, that it would be dangerous and that it would escape into the environment.
Is that an essential element of your claim, namely that the defendant acted with a knowing state of mind?
It is, Your Honor, in the sense that we must show that the harm was foreseeable. Knowledge is one way, probably the best way, to show foreseeability. And in this case, as the complaint alleges, from as far back as 1937, Monsanto knew not only of the toxic nature of the PCBs, but also knew that through the ordinary use of the products containing them, like paint and so forth, they would escape into the environment. So yes, Monsanto had that knowledge, and that made the harm foreseeable.
So an innocent, I'm just trying to figure out some line drawing here.
Sure.
So an innocent discharge into the environment over many years that later turns out to be harmful would not be a trespass action?
The weakness in that case, Your Honor, would be if there was no knowledge of the harmful nature until later, there would be no foreseeability. And that would be a case that, unlike this one, that would present problems for the plaintiff.
Mr. Durstein, I'd like to follow up on that.
Sure.
It's more, for the purposes of the trespass, as I understand your brief and the restatement, there has to be an intentionality which is defined as, in the restatement, or at least in a comment, as an act is done with knowledge that it will, to a substantial certainty, result in the entry of the foreign matter in the lands, correct?
Correct.
Where in the complaint do you talk about or does your client talk about substantial certainty? I've located some allegations that they knew, but am I right that you have to plead and ultimately prove that they knew with substantial certainty that these materials would end up in the specific places identified in your complaint? Is that a correct statement of the test?
I would agree with that, Your Honor, except for the specific places part of it. I think we must show that Monsanto knew the materials were toxic, knew the materials would escape into the environment, and that part of the environment has to include public lands, which is what the Attorney General sues on behalf of it in this case. As far as specific locations, I think it need not be specific other than state lands and waters, which is the basis for our lawsuit.
So is it your position that you've pled essentially that this is universal liability in all places because of the nature of how PCB spreads?
I'm not sure we have pled universal, and I'm not sure I would argue that. In this specific instance, we have shown that Monsanto had the knowledge of the toxicity, and early on, as far back as the late 30s, had the knowledge these materials would escape into the environment. Now, as to where, it became obvious later on, while they were still producing PCBs, that PCBs would remain in the environment for a long period of time, could be transported by water and to some extent through the air, and would end up in many different places, including public lands and waters of the state of Delaware. So that was within their technical knowledge and expertise internally in the company while they were still producing this product and putting it out into the stream of commerce.
I have a question. Is the cause of action public nuisance, is that arrived at essentially by a process of elimination? In other words, did you considered and concluded that you didn't have any statutory claim or other common law claim? How did you arrive at the public nuisance claim? I know that there are cases on it in other jurisdictions, but
Your Honor, I guess it would be fair to call it a process of exclusion. I don't think it matches up well as a products liability claim. And we've tried to be careful in our papers to say that's not what this is. And merely aggregating a number of individual claims, as in a kind of class action, does not create a public nuisance. But when we look at the elements of public nuisance and the role of the Attorney General under the public trust doctrine, this case matches up very well. And the same goes for the trespass claim. A public nuisance involves an interference with the rights of the community at large. And what better example of that, going back to common law, would be lands, wetlands, waters of the state of Delaware that everybody would like to use. Everybody would like to eat those fish and be able to engage in recreation in those waters. So we felt, yes, that these were the causes of action and the unjust enrichment claim that best matched these facts. And it's different from a products liability action, and defenses that Monsanto claims to a products liability action have no application here in this case, because that's not what this case is about.
Isn't it also different than a traditional public nuisance claim, which involves the use of the alleged tortfeasor's land and its effect on contiguous or roughly nearby land?
Your Honor, I would say it's different from the typical private nuisance claim, which is going to involve typically adjacent land. However, it's much more like the classic public nuisance claim going back to common law. In fact, it's more like classic public nuisance, contamination of land, pollution of land, by something upstream than the firearms and opioids and lead paint cases that Monsanto wants to rely on. That's a different analysis, different facts from here. We believe some of those cases in the court below were wrongly decided, but we're dealing with distinct facts in what's before the court today. And the reason why we thought public nuisance was a good match as a cause of action and trespass is because it fit those criteria. It is very close to what the King of England was doing hundreds and hundreds of years ago to remedy some kind of harm to lands of the crown. Whether it's PCBs, a modern chemical compound, as opposed to manure or whatever it was in the 1200s or 1300s, the legal analysis is the same.
When the king was doing that, were British subjects entitled to bring a cause of action in the courts? Or was it unique to the crown?
Your Honor, you're testing my knowledge of the common law, but I believe that private subjects were privileged to bring private nuisance actions because the commentators tell us that private nuisance has at least as long a history as public nuisance. And they existed side by side, but very different elements. And to the extent Monsanto rules on some private nuisance cases to try to limit the scope of this cause of action, they don't apply here. That's why the element of control doesn't apply here. It's a different analysis. Control could be a factor in determining whether Monsanto should be held responsible, but is not a standalone element. It's better to factor that through the proximate cause analysis, looking at causation, and the foreseeability. And those are questions that are factual questions, by and large. We're here on a motion to dismiss, and this is the kind of case where it is not appropriate with respect for the lower court to take this case from the fact finder when there's a detailed complaint that sets forth these allegations and discovery is yet to be taken and this case has yet to be proven. But the state at this point, for Rule 12 purposes, has made out these causes of action.
To the extent that you're asking this court to essentially expand the Delaware common law in these three areas, why isn't it more appropriate to go visit with the legislature as a matter of public policy instead of if it's regulation you're really after as opposed to the judicial branch?
Your Honor, we are not asking the court to expand the scope of these common law actions. In fact, we believe that Monsanto is looking for a special products exception that did not exist at common law. We believe that this case can be evaluated under classic common law tests. And for that reason, to answer the court's other question, we don't believe it is necessary that the legislature address this matter. It's important, and Monsanto refers to this, our General Assembly and the United States Congress have certainly addressed the problem of PCBs in the context of statutes like CERCLA, and the state has done the same. And that indeed has led to individual sites, including some within the state of Delaware, being remediated, cleaned up. That's fine, that's appropriate, and that statutory and regulatory scheme has accomplished that. That does not create some kind of immunity on the part of Monsanto for the consequences off-site of its conduct in originating that toxic chemical and distributing it to these other manufacturers, knowing it would end up in the environment. So, no, we don't believe that there's a legislative fix for this that would be more appropriate. We think that the public trust doctrine gives the Attorney General the authority to attempt this remedy. And I might also add, these remedies are narrow. We're dealing with a kind of floodgates argument in the brief by Monsanto. And this is not a floodgates situation. This is what this court, referred to as the orderly evolution of the common law. It's kind of like the new wine in the old bottle. We're only asking the court to apply to a familiar fact pattern these common law tests against a defendant who knew perfectly well what they were doing and what the consequences would be. As any other responsible defendant, they should be held liable. Another way to look at this, and Monsanto in their brief talks about allocation of risk, which is a little far from a strict legal analysis, but since they've opened the door, it seems to me when you look at a fair allocation of risk in guiding the court's decision, in this case, other local companies have had to do some cleanup. We know this. And the taxpayers have had to pay for some of that cleanup through work that DENREC has done. Ought not Monsanto, as the originator of the problem, be held responsible for their part in this? And their part in it, in this case, is not individual claims or private landowners. It's only state lands held in common under public trust by the state of Delaware. I don't want to, if this case goes forward and is reversed as we would like, I don't want to undercut our argument on damages. But the damages at common law are limited to the actual lands and waters involved in this case. The state is not suing on behalf of anyone else. I don't have any individual clients, just the state of Delaware.
If your theories are accepted, for instance, your trespass theory, that would be a cause of action involved to literally or virtually the entire population, would it not? And I guess what we're all understandably struggling with is what is the limiting principle of your theory here?
Your Honor, I agree that I think the suggestion behind the court's question that we need guardrails. We need to confine this cause of action to what it is and what it is not. One way to approach that is to look at the elements of common law, public nuisance and trespass, and unjust enrichment, which are pretty demanding of a plaintiff. And the other way to look at it, I think, is that in this case, we have what I would call a unique set of circumstances in that we have a sole distributor with knowledge for 4 decades of the problem, knowing of the escape or leaking into the environment, and persisting in the conduct that directly caused the harm we're here suing about. I don't think there will be that many cases with that kind of evidence, that strength of evidence. These cases nationwide, as the Legal Scholars Brief points out, are quite rare. Public nuisance cases are rare. Trespass cases based on this kind of analysis are rare. But when they're brought, and courts have overwhelmingly accepted them, that's the majority view, they have led to significant reimbursement and recovery on the part of those jurisdictions, so states and local municipalities. So I don't think, with respect, that it's going to be a floodgates problem. I think this court has the ability to spell out what is and is not a viable claim, but within that universe, these claims ought to be ones that can go forward in the lower court. Let me deal just in the few moments I have, reserving some time for possible rebuttal. Monsanto relies, as I think I've mentioned before, on 2 cases from other states. Oklahoma, it's an opioid case, and Rhode Island, a lead paint case. But the difference is, and perhaps this helps show how narrow these causes of action are, those 2 state courts struggled with the question of whether opioids and lead paint, respectively, were an interference with a public right, which is one of the elements, as the court knows, of public nuisance. That's not in question here. Monsanto recognizes that the harm sustained on state lands is, in fact, an interference with a public right. Monsanto argues they're not responsible. So this case is readily distinguished from those decisions because we already have the basis for a public nuisance. The only issue is causation. Causation and foreseeability in this case are very different from an opioid case or a firearm case or a lead paint case. They're more direct, they're more directly proven, and we have drafted a very detailed complaint in this case to set out that history and that pattern of responsibility on behalf of Monsanto. If the court has no further questions at this time, I'm going to sit down and reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. Excuse me, may it please the court, Kim Coker for defendants, and thank you for permitting me to present the arguments on their behalf today. What the state seeks in this case is a radical departure from Delaware principles, nuisance and trespass, which are at their origin land-based torts, and to replace that with an unprincipled, unpredictable theory of liability that will affect numerous and countless product manufacturers who sell products in Delaware, who will be forced to make a decision between either adopting new duties to monitor, control, and even potentially test end products manufactured by third parties, but also to potentially just cease selling products in Delaware to avoid liability. The state's focus has been on the condition, the alleged nuisance condition. And yes, the there's Delaware case law that has established pollution as a nuisance condition. Monsanto hasn't conceded that it's a nuisance condition. We just haven't focused that on for purposes of our motion to dismiss. The artesian water case clearly cautions courts not to impose nuisance liability solely based on the condition, but to focus on the conduct. There has to be liability producing conduct. And in Delaware, the test for common law nuisance has been control over the instrumentality or agent at the time of the alleged harm. And that's been recognized.
What about knowledge of the harm?
Your Honor, a good example of the application of the test is in the artesian water case. And in there, that case involved a landfill owned by a county but operated by a third-party contractor. And in that case, in analyzing I believe it was a motion for summary judgment by the county, the court analyzed first whether the plaintiff had adequately established control over the agent, the instrumentality, the contractor that caused the nuisance. After the court was first satisfied that the plaintiff had established that the county had control over the agent, then it looked to the element of knowledge to see if the county in fact had knowledge of the agent's conduct. So there's a two-part analysis. Control over the instrumentality, it's not just based on knowledge of the resulting harm.
So I just want to understand, you're saying if I knew that a product that I was manufacturing was going to be harmful to the environment, I can insulate myself from liability if I don't control its distribution through independent third parties.
So in this case, Monsanto sold, PCBs are a chemical product that Monsanto sold in bulk to third parties. Third parties then manufactured their products, whether proprietary formulas for paint and caulk or dielectric fluids used in enclosed in capacitors. Then those products were sold to third parties and eventually ended up in consumers and end users. The notion that Monsanto would, there's no insulation or immunity from liability. There's no affirmative conduct that creates liability in the first place. So it's not immunity from liability. There's no conduct that gives a rise to liability in the first place. A manufacturer doesn't have a duty, a common law duty, to monitor and control and test third-party products and ensure the safety of those products. If that were a duty imposed on manufacturers, that would be an immense policy shift in Delaware, causing manufacturers to essentially control the distribution, absolute liability, cradle to grave, to control and monitor the safety and efficacy not only of their raw materials but the end products in which they are used, use and disposal eventually by third parties.
While we're on this topic, the control cases seem to have a common element of a third-party actor who sort of triggers the harm. For instance, in an opioid case, the user or the prescriber, perhaps, gun owners, cause harm with the gun. But if I understand the state's theory here, it's a mere act of manufacturing and putting this out into the stream of commerce, knowing that it is likely to spread throughout the environment. Doesn't that change the how we should look at control?
Again, Your Honor, so the Monsanto sold PCBs as a bulk chemical product. It didn't manufacture the third parties, the applications into which they were incorporated. Those were decisions made by third parties and then ultimately put into use and disposed of by third parties, over whom Monsanto had no control and whom the state doesn't allege Monsanto had control over. The difference between this case and any other case is that everywhere there's in third-party cases involving criminal conduct, some of the opioid cases have decided that that is not a interference with the public right, but in all these states that have decided public nuisance cases, they've rejected product liability, nuisance claims for product liability because of the lack of control of the instrumentality after the point of sale. And if the court were to adopt that form of liability in Delaware, it would open the floodgates to potentially limitless and unpredictable liability to nearly every manufacturer that sells a product in Delaware, because we all know that motor oil, plastic straws, bottle caps, antifreeze, cars themselves inevitably end up in the environment. There's no limiting principle to this theory of liability, and that would erode all of the principles, the long-standing traditional nuisance principles in Delaware, and create an entirely new tort. And its application would be particularly unfair in this case, since Monsanto ceased production of its product 45 years ago. And the defense suggests or urges the court to exercise restraint. If there's any type of remedy that the court believes would be appropriate, it should defer to the legislature, which has the resources available to conduct hearings and weigh the competing interests between the regulation of the sale of products in Delaware and the protection of the environment. Your Honors,
we have an allegation that Monsanto knew and was aware that the product would end up polluting rivers and streams. Does that knowledge have no legal significance?
So first, just historically, that knowledge became evident first through the beginning of Swedish scientists in the 1960s. In 1966, Monsanto became aware of that in about 1979 or 1969. By 1970, it began phasing out most applications and limited its sales to dielectric fluids and enclosed electrical capacitors. And in fact, it was by the insistence of the U.S. government that it continued to produce dielectric fluid, because it would cripple the electrical industry in the country if it didn't. And it wasn't until a suitable substitute was discovered that then Monsanto ceased those sales. And even after Congress enacted the Toxic Substances Control Act in 1977, it didn't ban the continued production of PCBs for 2 years until 1979. So that's the backdrop when we're talking about the state of knowledge at the time Monsanto produced its products.
You're outside the complaint now. I mean, we're just dealing with the motion to dismiss.
Your Honor, that material is included in the interdepartmental task force report and EPA reports that the state has incorporated by reference into its complaint. And that is on the record.
Isn't the argument you're making now the sort of thing that a trial court or jury would weigh when considering an element of knowledge or foreseeability?
The court would have to establish a test that eliminated the principle of control for a jury to ever decide this case solely on a question of foreseeability. The test of control is an element of liability under Delaware law, and that's established not only in the artesian water case that I discussed, but it's also in the patent cases. There are 2 patent cases. We cite one in our papers. This is a case involving an elevator shaft where a worker fell to his death. It's a nuisance case for damages in the Superior Court, and the court rejected a claim against both against the elevator repair contractor who put the nuisance condition back into operation, as well as another case that we didn't cite in our papers, but involved the mortgage company that owned the property, and the court held that the plaintiff failed to state a claim against both of those entities because neither had control of the nuisance condition at the time of the harm. And in fact, in the case involving the mortgage company, the court said that absent these predicate elements, there can be no liability.
If we apply the restatement, does the state get past the motion?
There are multiple different restatement sections that the state has cited. I'm not sure which restatement section you're on, or could you clarify which one you're referring to?
I don't think in the public nuisance area, our courts have had a chance yet to evaluate the restatement and how it bears on this. I'm just asking a general question. If the restatement law is applied to this claim, does the state get past the motion to dismiss?
No, Your Honor. Artesian water does discuss the restatement, and that's the case that first analyzes the element of control over the nuisance-causing agent at the time of the alleged harm, before even questioning whether the plaintiff established knowledge on the part of the defendant.
Could you address the restatement's treatment in the trespass context of knowledge as a substantial certainty that the foreign matter would enter, and your friend's response that so long as they were substantially certain that the product would be dispersed generally into the environment, they don't have to show that or allege that there was knowledge with substantial certainty that the foreign matter would enter specific lands.
So first of all, the Dayton case establishes that the intent to trespass requires an intent to enter the particular piece of land, and there are no allegations in this case that Monsanto intended PCBs to enter Delaware lands and waterways that are at issue in this case. As far as the knowledge requirement, that's a piece of trespass, but like nuisance, it is the element of control is a predicate to liability.
Well, when we get past control, we would then look at knowledge and intent, correct?
Oh, yes. I'm sorry, I misunderstood the question. If the plaintiff, which the state has not done, can establish control over the instrumentality, then the next question would be the state of mind. And did at the time of the intrusion, the defendant intend for the instrumentality to enter that piece of land? And Your Honor, just to reinforce, the control element is established in Delaware case law. In the Robinson case, that involved a contractor who developed in conjunction with a developer, with a development company, a stormwater runoff system, and the court held that dismissed the claim against the contractor because the contractor was not in control of the instrumentality at the time of the alleged harm. And also Dayton, which I mentioned, is another case that enforces the element of control as a predicate to liability. And there were homeowner hired contractors to cut tree limbs, but did not exercise control over the contractors at the point they entered the plaintiff's property, and the court held that the homeowner was not liable in trespass for the entry by the contractors over whom they had no control. I'd like to also bring Your Honor's attention to the New Hampshire Superior Court case. That's the State versus 3M cited in our papers, and that's a very similar case out of New Hampshire, similar to this case involving PFAS chemicals, where the state sued the manufacturer of PFAS chemicals that the manufacturer sold to multiple parties throughout the state in a chain of distribution similar to the chain of distribution at issue in this case. And the court rejected the trespass claim because the manufacturer had no control over the PFAS after the point of sale. Your Honors, also on the issue of standing with respect to trespass, we ask that the court also affirm on the independent basis of the state's lack of standing to sue for trespass. The state has narrowed its claim to trespass to the sediments beneath state lands and waters, and there are several cases specifically cited in our papers, specifically holding that state or sovereign that holds land, including sediments, in public trust does not have the requisite possessory interest to state a tort damages claim for trespass. And those are the New Jersey versus Hess case, the New Mexico versus GE case, and again, the state versus 3M case. And I'd like to just touch briefly upon the unjust enrichment claim. We agree with we stand on our papers for the majority of the arguments, and I'd just like to say that the Superior Court correctly ruled that that the Superior Court does not have jurisdiction over an independent claim for trespass, but regardless of the jurisdictional question, the state failed to state a claim. It has only ever asserted or pinned its unjust enrichment claim to the contingency of its nuisance and trespass claims, and has never stated an independent basis for liability under its unjust enrichment claim. And because it's merely duplicative, we also ask that that be dismissed, that the dismissal of that claim be affirmed. And just in closing, Your Honors, because the state in Sills, Purdue, because the Superior Court in Sills, Purdue, and in this case has now 3 times ruled that Delaware does not recognize public nuisance and trespass liability for the sale of a product, we request that the court affirm the Superior Court's decision and respect the traditional common law principles of liability for public nuisance and maintain consistency and predictability for the sale of products in the state of Delaware. Thank you.
Thank you very much.
May it please the court. There was a question about allegations in the complaint from Justice Traynor, and I just want to point quickly to the degree of specificity in this complaint as to Monsanto's conduct over a period of time from basically 1937 through 1977. Paragraph 84 talks about how Monsanto repeatedly misrepresented the risks posed by PCBs.
Does misrepresentation have anything to do with?
I'm sorry?
How does misrepresentation fit into this?
It relates to causation and foreseeability. Monsanto, in effect, is arguing that third parties to whom Monsanto sold PCBs somehow intervened in this chain of causation. They ought to be blamed, is the nature of their argument. We believe that's untrue and unfair to those companies because Monsanto was repeatedly reassuring them that these PCBs were safe, that the products that they were putting them in would not cause contamination. I think the court was correct in focusing on the element of knowledge. Knowledge is an important element both as to causation and as to foreseeability of the harm. And the court asked about the restatement. Restatement of Tort's second, section 834 says a defendant who creates a nuisance will remain liable even after the defendant ceases its tortious activity and even if the defendant is no longer in a position to abate the nuisance. Obviously, the state can't seek an injunction if there's if Monsanto is not actively engaged in it, and we don't seek an injunction in this case, we seek damages. But the restatement recognizes in that instance the continuing responsibility of a manufacturer like Monsanto. Again, knowledge is the element. Cases have held that public nuisance turns not on geographic proximity, as Monsanto would like it, but on knowledge that its activity would endanger public health. And the complaint alleges that in very specific detail. As far back as 1875, a treatise on the law of nuisance by Professor Wood recognized that a defendant need not commit the particular act that creates the nuisance. It is enough if he contributes thereto, either by his act or neglect, directly or remotely. That was the law back then in the 19th century, and that's the law today. It's the common law we've inherited. This, it seems to me, is a case where this court can fairly look to courts in other states that have recognized the viability of these common law causes of action in this instance. And incidentally, if we look to those states, if we look to Oregon, Maryland, and Ohio with respect to trespass, and if we look to Illinois, Maryland, and Pennsylvania as to public nuisance, where they have allowed causes of action, I do not believe we would find a floodgates problem in those states with an excess number or an astounding number or an unusual number of public nuisance or trespass cases being brought on this theory. In fact, it is an unusual case, fortunately, for the environment, but one in which a cause of action, these causes of action, are justified. The Court of Chancery held back in 1958 that regardless of these kinds of expansion or floodgates arguments, the court must decide cases according to law and not in light of their possible effect on the caseload. And I trust that that is what this court would do in this instance. With respect to trespass, and again, since there was a question about the restatement of Tort Second, Section 163, cited in our brief, holds that in this context, exclusive possession means the right to exclude others. And that's a point that was raised in Monsanto's brief, and I don't want to avoid mentioning. Exclusive possession does not mean sole possession, does not mean that the holder of the land, the state in this instance, would have to exclude everyone. The state can allow people in state parks, can allow people to fish and hunt on state lands, and still retains the ability to deal with trespassers like Monsanto who cause harm to those same lands. There's no immunity conveyed on a wrongdoer by the state allowing individuals onto those state lands. In fact, it's at the heart of the public trust doctrine that the state is holding these lands not for itself, but for the use of the citizens. So the use by the citizens is entirely consistent with the public trust doctrine, as is this lawsuit. The question raised by Restatement Second of Tort, Section 158, is whether Monsanto knew to a substantial certainty that its actions would result in PCBs entering Delaware's lands. That's a relatively high standard, as I think the court would agree, but it's satisfied here in the papers, in the complaint, because of the knowledge element. Monsanto, we have shown in these allegations in the complaint, knew for a period of 4 decades of the harm, did not disclose the harm to regulators, to its customers, to the public at large. And the other part of that is, it's not just sufficient that PCBs were harmful, but that PCBs would escape, they would drain out, they would end up in the environment. And that element, as we allege, was also known to Monsanto. So they had all the information in terms of knowledge before them to act responsibly as a company. And they waited until 1971 in part and 77 ultimately before they did that. The state, government, other potential plaintiffs should not be blamed for failing to take action when they were not aware of, until later, the harm that might be sustained. I believe, unless the court has any other questions for me, that's all that I need to say at this point.
Thank you very much. I just want to pause for a second and recognize that this is Justice Vaughn's last oral argument. He's been a wonderful colleague on the court. We're going to miss him dearly, but I didn't want the occasion to go by without recognizing and thanking him for all his public service over the years. You may recess the court.
Please rise. Hear ye, hear ye, hear ye. All men or persons having anything before the Supreme Court of the State of Delaware may now depart and give their attendance to the call of court. Court is now adjourned. God save the state and the honorable court.
Okay.